Good afternoon, everyone, and thank you very much for joining us today. We're delighted to welcome you to the Shepherd and Wedderburn Brexit webinar, covering one important question: are you and is your business referendum ready? This webinar, for those of you who have been following, is the culmination of our publication series where we've covered the ins and outs, the detail on the outcome of the European referendum, and those were in-depth briefing notes focusing on all our practice areas and industry sectors. From memory, I think we're up to about somewhere between 26 and 30. So your speakers today will be me and Louisa Knox and my partner Gordon Downey. We're both partners at Shepherd and Wedderburn, and we have, as a firm, been advising and training businesses and individuals on the legal and regulatory implications of both a Remain and a Leave referendum outcome. We've thoroughly interrogated both scenarios and provided, and have been still and are ongoing, providing advice and commentary for our clients in looking at how the developments are going to affect them and their businesses, whatever the outcome of the referendum. So the one thing that is certain out of all of this is that UK voters will be going to the polls on the 23rd of June to decide whether or not we will stay in or leave the EU. So let's look at the two possible outcomes. Remain vote is largely, obviously, business as usual. The David Cameron deal, the EU-UK settlement agreement, will come into force. There has been a lot of some scepticism about what that deal actually means, but changes are going to be introduced in key areas: one, sovereignty; the second, competitiveness; thirdly, economic governance; and fourthly, immigration. Obviously, in the time which was allowed for the settlement agreement to be reached, it did not go into the details of how the four changes would be achieved, and as I said, there have been some significant questions over the true impact and whether or not they're relatively minor tweaking or whether they have true merit and impact. So from an immigration point of view, it's very much a watch and see. The welfare and benefit changes may or may not have a significant impact. But in the other three areas, the changes will have a degree of time lag. It's looking like that will take some time to go through. The UK might be looking at reducing the regulatory burden, and will have this additional veto for the Commission proposals. That's obviously not going to have an immediate effect, particularly where our domestic legislation does go further than the requirements of the EU. However, I think one thing is quite clear is that the new settlement terms will be scrutinised, and we have the backdrop where the European Court of Justice could actually weigh in on top of all of this and make decisions which are not quite envisaged by any of the member states, including the UK at the moment. So it is, however, the Leave outcome that has created the most uncertainty and speculation. I think in any event, the financial markets, in the event of an out or a Leave vote, would be, there'll be a rocky road ahead, but there are also the legal uncertainties of the exit procedure. I mean, we're into uncharted territory, so we don't have a precedent to follow. However, under the EU rules, there will be a maximum of a 2-year negotiation period between the remaining member states and the UK on the terms of our exit and also on the post-exit relationship with the EU. So the four possible models that have been discussed widely in the press, the Norwegian model, the EEA, Swiss model, Turkish and the Canadian World Trade Organisation-based relationship, have all been mooted, but our belief is that it's much more likely that in fact what we'll see is some form of bespoke UK model in that event. One thing that is critical out of all of that is that none of these countries who've got different models have influencing power within the EU, and those businesses which are trading will have to comply with the EU standards and regulation if they want to benefit from accessing that. So I think that's a key point, and something that's certainly been put forward regularly by the Vote Remain side. So let's look at the models in a bit more detail in the event that we do leave. As we said, we fundamentally believe that it will be a bespoke UK model, so you may see strands from different ones, but the negotiation will really depend on the political climate within the UK and, critically, the desire of the remaining EU member states to negotiate with us and to give a deal that will work for all parties. And obviously the challenge will be in achieving agreement among the remaining 27 member states. So if we look at the top right here, we've got the EEA model, the Norwegian model. It's probably the most integrated out of these with the EU. And whilst there is, a range of different benefits which are available, the drawback is that they cannot influence EU legislation, but they do have to comply. If we look at the Swiss model, it's based on bilateral treaties, and although the Swiss do have a significant degree of independence, they do acknowledge that basically where they're sitting in Europe and their economic ties with Europe, that largely the Brussels-driven regulation is embedded into their businesses, albeit that they don't have much say again. Turkey, as well as San Marino and Andorra, form part of the customs union, and they obviously have access to free movement of goods. Now, the Canadian example has been used in the press mainly because Canada is trading with the EU under the auspices of the World Trade Organization rules, and they have, for those of you who've been following this in the press, they have recently concluded the Comprehensive Economic and Trade Agreement, the CETA, which is at the moment awaiting ratification. So that would tackle a range of issues. It would open up the services market, remove customs duty, and end limitations in access to public contracts. So possibly a bit more predictable conditions for investors, but critically they will stop illegal copying of EU innovations and traditional products. So obviously a bit of a two-way street. One thing I should flag, and it's probably not a surprise to anyone who's dealing in the European arena, the negotiation with Canada was launched in 2009. Agreement was finalised in 2014, and we are still waiting for it to be ratified. So nothing moves slowly in Europe, which is where the 2-year time period will be a huge challenge to all involved. And we're much more likely to see high level, as we often do with Europe, high level commitments as opposed to fine-tuning or detail. So we do think that any free trade agreement will take years, and what will be interesting or critical during that period is what will the implications be for the trade flows during that spell. So let's turn now, we're going to use a case study today. So we've selected a product that is important to the lives of many in the UK, possibly particularly me, chocolate, and also Belgian waffles. So we're going to think about what questions would a chocolate making business operating in the UK and EU be asking about the referendum, and what are the legal areas that they should really be focusing on at this time. So here we've got a pretty standard operating business model. We've got the holdco sitting in Luxembourg, 2 operating companies, one in the UK, one in Belgium, producing respectively the high quality chocolate and the waffles. Distribution is by vertically integrated distributors operating in different EU member states, so quite widely across Europe. So we do appreciate that your own business model or interest may be slightly different, but we'd ask you to bear with us because obviously there are some fundamentals that flow through any form of business, and we'll be using it to highlight different issues, some of which will clearly be relevant no matter what business area you are in. So if we look at some of the key issues that you are bound to come across in whichever sector you're working in, I mean, one of the first things probably to say, if we look at all these issues on this diagram, and we have been advising clients to do this, the content of the risk register is key. This should be embedded in risk registers across the business. If you are operating in Europe, then you should be looking at a potential Brexit as a fundamental risk. The risk may be low depending on the reading of the polls at the moment, but the consequences obviously from a legal perspective are pretty high, and early preparation is going to be important. So we're just looking at some of the issues that we're likely to come across here. We've got a variety of different ones where we're going to see competition procurement, intellectual property, data protection, looking at the property side, energy side, free movement of people, employment. So whilst a lot of the changes will not be immediate, it will not be an overnight change. As if the UK received greater sovereignty, there could over time be a greater divergence from the EU structures and laws to where there could be more UK based, and obviously restrictions being placed round about the UK as a result. So I think to the extent that you do have operations in Europe, one of the key questions that we have been asked in the lead up to all of this is what happens to the movement of people? I've got secondees working in Europe, am I going to have to bring them back? What is going to be the biggest impact? Freedom of movement of goods and capital is also another one having a potential impact on the capital flows. And then looking at the more micro level, contracts having to be reviewed for compliance in a new commercial framework, but potentially also they should really be reviewed in the lead up. So I'm going to turn now to Gordon, and he's going to pick up on various subjects, and then I'll come back to talk about some of the employment pensions related issues. So if I hand over to Gordon to look at free movement of goods.
Thanks, Louisa. And just as a preliminary, there are a few topics which I'm going to cover. I won't go into as much detail as appears on the slides, just in the interest of time, but I will try and bring to life some of these points by reference to the case study example. In relation to free movement of goods and market access, a couple of things I wanted to emphasise here in relation to our case study. Clearly there's a wide distribution network which has been established by our hypothetical group across Europe. In the event of an exit from the EU, clearly the issue of customs duties and tariff barriers needs to be addressed. Within the due diligence, if you like, that is carried out on the distribution framework for our hypothetical company or group, one of them I think will need to be how would the issue of tariffs or customs duties be resolved as between the manufacturing part of our business and the distribution network? Who would bear responsibility for those duties or tariffs? And that would be something to check in any contract due diligence. Secondly, in relation to market access, UK businesses at the moment who face discriminatory behaviour or the like from other EU member states have the ability to rely directly on EU law before the courts of those other member states. So, for example, if our chocolate operating subsidiary was facing barriers in France, for example, we would be able to rely directly on the French courts on EU law to protect ourselves. That will no longer be necessarily available to us under a different legal regime governing UK-EU relationships, and that would need to be borne in mind in terms of marketing strategy in these other member states. In terms of capital, the broad point I think that would need to be thought about by the group would be how would the fact that part of our group, i.e. the UK operating subsidiary, was going to be outside of the EU, how would that affect the ability of the group freely to reorganise or restructure the group's capital arrangements, given that free movement of capital wouldn't necessarily form part of the post-exit EU UK arrangement. Moving on to general contract considerations, a list of things which clearly would need to be looked at as part of a due diligence exercise, examining the risks arising under our key contracts in the event of Brexit. Those are listed generally on the slide. I think in terms of the next slide, looking at e-commerce, for example, there are some quite important considerations to be borne in mind to the extent our products are being marketed on the internet. There is at the moment a European Commission investigation into the phenomenon known as geo-blocking, where various e-commerce platforms are able to, at the moment, segment different countries, customers in different countries, and limit access to particular promotions and discounts. may well be that the European Commission looks to remove that geo-blocking phenomenon within the EU, but if we're no longer in the EU, then there may well be continuing scope to geo-block our market to the extent that's in the UK. In terms of tax, Louisa, I think we were talking about some of the considerations that apply there, notably in relation to VAT.
Yeah, absolutely. I mean, I think one of the things that we recognise at the moment is that people who are operating, or businesses operating across the EU, benefit from the general corporate tax rules and non-discrimination. So I think that does help for some clarity. And obviously we've also got the EU Parent Subsidiary Directive, which allows for favourable tax treatment for member states. So that would need to be looked at if there was a Brexit, so that the UK would either look at these third country treatment negotiations, or they would certainly have to do something different where it was double taxation treaties, and I think, you know, the additional complexity of that would need to be looked at. So I think the concern is that from a corporate tax point of view, there's potentially additional compliance costs. From a VAT perspective, I think some businesses have been quite excited about the fact that because VAT is a truly European tax, and the concept, you know, the concepts that come through on VAT from the EU are then having to be dealt with within the member states. And I think that has, I know, caused some issues in terms of the European approach on VAT. At the end of the day, we do still have control over the VAT rate, but I think it will be quite interesting to see. It's certainly been hailed as, well, basically, can we get rid of VAT? There is no question. I'm quite happy to say I do not see VAT disappearing. It will still be a UK tax and still subject to lots of challenge, but we might just not have, in the event of a Brexit, the extra complexity of the EU's rules. But it's definitely, it's one to watch, and I know it's been one that's been hailed as a potential get out, but I don't see it getting us out of anything.
Okay, thank you, Louisa. Moving on to the broader question of product regulation, clearly in the case study example, we have a directive mentioned on the slide there, which does regulate the manufacture of chocolate, and in the event of Brexit, there's certainly a phenomenon which we see across different sectors, in terms of which we escape from the harmonising effect, restrictions, if you like, of directives such as that, and so become at liberty, if you like, to alter composition of products such as this without breaching EU law. On the other hand, to the extent we do choose to diverge in how we manufacture these products, there may be consequential restrictions on our ability to market those products within the EU. The other point which is mentioned on the slide there, which is quite interesting, is protected geographical indication. So in other words, the ability to protect the use of expressions such as Parma ham within the EU jurisdictions. Looking, for example, at the concept of Belgian waffle, if Belgian waffle were indeed PGI status, at the moment our chocolate waffle business has the ability to use that sort of PGI protection to ensure that non-authentic products, if you like, non-PGI products, aren't able to be marketed in a way that would undermine our offering if we're no longer in the EU, and, for example, a non-authentic Belgian waffle, let's say, was being promoted within the UK market. We wouldn't be able to necessarily rely on PGI law to defend our market. In terms of more broadly protecting our brand and our product, IP is obviously a key consideration for this business. And one of the things we need to review as part of our due diligence for Brexit would be the extent to which we had used community trademarks and registered designs to gain that protection rather than seeking that at national level. And if we had done that, then it would be a question of looking to reinforce what we had at community level or EU level with, for example, UK intellectual property rights. And on data protection, which is also mentioned in that slide, clearly one of the newsworthy topics of late has been the question of transferring personal data outside of the EU. In the Brexit scenario, clearly the UK would be outside the EU, and so one of the things that our hypothetical group would need to consider would be how to deal with the transfer of customer data from within the EU to, let's say, the UK operating subsidiary. Energy, interesting topic. In the context of this case study, it may well be that the chocolate production unit in the UK is, as we've flagged on the slide, a relatively high intensive energy user. Outside of the EU, there may well be greater flexibility that the UK government can have as regards sheltering the chocolate production company from the costs of energy, high costs of energy. But one of the factors that may well be included in a future UK-EU trade deal is some form of state aid analogue which would prevent us from unfairly advantaging our domestic production, so that would need to be borne in mind. In terms of question of litigation and managing legal disputes, we've already talked about the loss of the direct effect regime and what that might mean in terms of using EU law to protect our case study company in disputes in other member states. It should also, of course, be borne in mind that the rules on recognition of foreign judgments and the enforcement of judgments in other member states under the Brussels regulation will be lost in the event of Brexit, and therefore careful examination will be needed of the ability to enforce, for example, UK judgments in other parts of Europe. On property and planning environment, which is the last thing that I want to touch on before I pass back to Louisa, certainly again, it's a familiar theme. Leaving the EU will confer greater flexibility on the face of it within our real estate sector as to the standards, for example, energy efficiency standards that our buildings will have to respect. However, to the extent that commercial premises, for example, are built to different standards, that may impact on their attractiveness to the real estate investment community, who may be looking for an EU or European-wide standard against which to invest.
Okay, so if I jump back in now on free movement of people and looking a bit at the employment position. So in the event of a Brexit, in theory at least, the UK would be entitled to restrict immigration from the other EU member states, and also, as has been mooted, it would be able to impose restrictions on EU citizens who are not UK nationals who are currently living in the UK, and vice versa. EU member states would be, in theory, entitled to do the same. So I can't see a situation where, and I think all political parties have already said that, no matter what, people who are already residing in the UK would be able to remain. And I do believe that whilst one of the fundamental tenets of the EU is about good neighbour relations, I think it would be very difficult for anyone, any member state, to start expelling nationals. But clearly, there's a pretty fluid state in Europe at the moment, but certainly that I don't think there'll be a significant change at the moment. And I do not see that having an impact. If we look at the UK and EU employment laws, in this country we love to comply. We love to not only comply, but we like to gold plate our compliance. And I would say that the employment area is just a very good example of us having done so. So if we look at all the various EU regulations and directives which have been implemented on employment, so we've got the business transfers, the transfer of undertakings or TUPE regulations, where we have done a bit of gold plating. We've got the working time directives, so those of you who are sitting perhaps in the HR side have had to work through hours of work, rest breaks, holiday entitlement and pay, the redundancies and the collective consultation, again, that has been fully implemented. Equal treatment directives, so we have seen non-discrimination provisions brought in on a wide range, which we've seen flow through to pregnant workers directives, part-timers. So there have been a range of areas where we have not only complied, but we have topped the compliance, all to the benefit, obviously, of employees working in the UK, but perhaps where we've seen a bit more press coverage about, that gold plating and the cost to UK industry. But certainly, if you look at the other models in any bespoke model, it's very difficult to see how free movement of people would be permitted even in a bespoke deal. If we turn now to pensions, a number of our clients have faced phone calls. So if I'm sitting as a pensioner, so I worked in the Chocolate Factory in the UK, and I decided to retire to France. So I'm sitting in France and I am receiving my UK-based pension, but obviously I get it paid in euros, so I've taken a bit of a currency risk there. But a number of these pensioners will be on the phone to your own HR departments in the next period or to your pension administrator asking, is their pension safe? And the issue from pensions is that it's a UK-based set of legislation that protects our pensions. So we've got domestic trust law, domestic contract law, which is already sitting to protect pensions. And I can say that pensions which have been built up or pensions which are already in payment are still subject to the same provisions. Obviously, there's no guarantees in life. You still need the sponsoring employer to be strong. So as long as our Chocolate Factory is doing a good business and has a strong financial covenant, those pensions will continue to be paid via the either contractually based or the trust fund that is supporting them. And I think that is something we've seen a significant number of questions coming through, and you'll have seen the recent press about UK nationals who are living in Europe looking to be able to return to vote, and obviously there was a recent case where they haven't been allowed to come back and vote in the referendum. Within the pensions arena, we've seen significant requirements pulled through from the IORP directive, principally into the area of investment and more widely. Now that did form the basis of the Pensions Act 2004. Again, we have complied. But what was critical there was the UK, because of its base in traditional final salary schemes, we have had, in our insurance industry, we've had a voice at the table through the European organisation IOPA, and that would be something that the influence would go, where we would end up compliance without influence, potentially in the area of pensions. So if we move on now and look at insolvency, so things have not gone well with our Chocolate Factory, and we're facing either a restructuring or an insolvency. What happens there? So within the UK, those of you who are familiar with the regime, we have a well-established, flexible and creditor-friendly restructuring and insolvency regime. There wouldn't be an immediate change to the UK's position, but where we do see the UK at the moment is a favoured jurisdiction to carry out restructuring. So the cross-border restructuring may not be done through the UK to the same extent. There is the EU insolvency regulation, the mutual recognition for EU insolvencies, again creating a stable background, and I do think that that assists with lending and investment activity. And of course, you know, post-Brexit funders would want to make sure that the organisations they're funding remain as stable, and that's certainly something that we have seen coming through, and the questions we've seen coming through. So, as I mentioned earlier, we have produced a variety of briefing notes. Somewhere, I think we're sitting around about 26, 30, something like that. Here's just a few of the more recent ones. Those of you who've got particular interest in your sector or in your own areas might want to just sign up for them and have a look. And obviously, I can see that some of you have been asking questions as we have gone through. We're going to answer some of those questions just now, but please do feel free, if there are additional questions post this session, to put them to either your usual advisor or to Gordon and myself. But thank you for your attention and listening today. So let's turn now to some of the questions that we've seen coming through, a couple of them on similar ground. Gordon, one coming through on, actually a couple of people have asked about this, material adverse change provision.
Yeah.
Now that's quite an interesting one.
Yes.
So I think the whole issue around, you know, what is the likelihood of a material adverse change clause being invoked to frustrate or get out of a contract? And my own thoughts, Gordon, I'll turn to you also, is that if you've got two contracting parties or more who are actually quite content and in the contract, they're very unlikely to invoke the provisions in the first place. But it is a risk if that contracting relationship changes, and you can see arguments. That's certainly something that should be, I think there should be diligence on contracts just now.
Yes, I think
it's key contracts.
As you said, yes, exactly, key contracts, looking at those key relationships to see whether any are actually subject to open-ended provisions such as that, which are difficult to interpret, to work out tactically how one should play the uncertainty with the counterparty, and whether it's in one's interests to try to crystallise the point. The other observation about those sorts of provisions is very much a timing one. As we've discussed, there is this 2-year period for separation following a vote to leave the EU. It's important for commercial colleagues to understand that clauses such as that may in fact not be triggered in the event of a no vote, but they may actually only be triggered on the facts and circumstances in the event of the exit actually taking place beyond that point, which may be some years away, and indeed may also be subject to maybe that a court takes the view that the question of whether there has been a material adverse change can only be assessed in light of the exit deal which is struck between the UK and the EU.
I think that's a very good point, and that's certainly something that could be put forward. I think we're both agreed that really a diligence on your key contracts should take place. You know, at the end of the day, whilst we think there are arguments over the whole thing, and I think that's a point well made about the prospect of actually saying this is not, it's not a material adverse change until it has happened, and the extent of that. But you can see contracting parties, and I know there's been quite a lot of discussion among various legal firms about whether or not those provisions would be invoked. So I suspect, as ever with these things, it depends on for whom they're acting and in what circumstances, how the arguments go forward. Okay, just looking through. Oh, here's one. What would happen to the UK borders, and would there be any change between Northern Ireland and the Republic of Ireland? So the UK's got control, we've got complete control over our borders. We operate border control security checks from people who are coming into the UK from other European states. There is a slight difference in that Ireland and the UK, Gordon, correct me if I'm wrong, we're the only ones to have opted out of Schengen. but we've got Croatia, Bulgaria and Romania all wanting to go in, but they've still not met the conditions to get in.
That's right.
But I'm just thinking off the top of my head, the UK and Irish borders are governed by there's a common travel area agreement which covers the Republic of Ireland and others, and I think it's not clear how that would change, if at all, following a leave vote. It then actually begs the question, doesn't it, about, there's been a lot of discussion about whether or not there would be a second Indie ref for Scotland in the event of a leave vote. And again, I think that all depends on the political will at the time. You know, it's been bandied about in the press that essentially the SNP could call for a second referendum, but that's correct, they can call for it, but it's not necessarily agreed. So I think, you know, it's almost, it's constantly moving.
Yeah, I think the UK, the Northern Ireland, Republic of Ireland border is very much one of these things which would have to be examined on its own merits. I think there's no way of predicting with certainty what the outcome of that would be.
Yeah. Now, I'll just read this question out. We're monitoring EU sanctions regime as part of our compliance process. How will that change in the event the vote is leave? So,
I think leaping in on
Oh, Gordon's just having a coughing fit. I'll maybe jump in. I'm right in saying, Gordon, that the EU has various powers to impose sanctions on individuals and businesses in third countries on foreign policy and security grounds, but that we look to the UN, or in fact the EU looks to the UN, doesn't it, in terms of its sanctions regime. But I think also we as a nation, I think we also impose some of our own sanctions. So whilst we implement the EU-UN sanctions, I think we do have a sanctions regime of our own. Again, I think this ties back to our need to regulate as a nation, which is strong. Now, I'm just looking again. Yes, I'm just trying to think how that would flow through. I mean, I think it all depends on the outcome, doesn't it?
I think the point about you made earlier about the leave vote, it's really important to remember that the leave vote itself isn't going to be a trigger for example, for EU sanctions to be removed from UK businesses. They will continue to be subject to EU sanctions. Even in the event of a leave vote, we remain a member state, and businesses operating within the EU remain subject to those obligations. So it would be very important to brief commercial colleagues that things like EU sanctions remain binding unless and until the conclusion of the exit negotiations.
Yeah. In terms of, I'm just looking also a question here coming through on actually the employment side and free movement, and do we have a sense, on the free movement side, in terms of, I'm just reading through the question, so post a Brexit, how quickly do we see the potential of free movement being affected? I think it would be some time, and the key thing here is you have to comply in the meantime. So there is no get out until we are actually onto a new deal or an exit package. You absolutely have to comply with the free movement. So an EU national has to be treated in the same way as a UK national when looking at job applications, etc. And I do think that is a point that actually it's not come up today in the questions, but I can say it's a question that has been posed to me on many occasions about directives which are coming into force and existing directives. What are our obligations during the 2-year period? And I'm quite happy to say your obligations are to comply fully, and our obligations as a member state are to comply fully, because at the end of the day, the country will, potentially we can be fined for that, but also there'll be, enforcement place. So I would say, unless people want a rocky road to litigation, we just have to comply until we're out, or we have a revised status. Would you agree with that?
Yes, I do. Yeah, makes sense.
Yeah, absolutely. Well, I think I can see there's another couple of questions, so I think what we'll probably do is come back to people individually. I'm just conscious of time marching on, and I promise to let you all get back to your desks in time for your afternoon's work. So can I thank everyone today for attending? That's been very much appreciated, and please do get in touch in the event you have further questions. Thank you all.